Welcome. We're super excited to have you join our new series, Million Dollar Breakdown, our biggest verdicts from the attorneys that won them. And we're going to delve into a significant case with a significant award. And we have star Morgan & Morgan attorney Ryan Skertich with us, who recently won a huge verdict in a case that revolved around a truck loading incident. Ryan, thanks for joining us.
Yeah, I appreciate you having me on. I'm glad to be here, Carl.
Super. So let's kick this off by asking you to give a short summary of the incident that led to this case.
Yeah, sure. So this case, this was all the way back in January of 2018. Mr. Barksdale, my client, worked at a Amerisource Virgin. It's a large company where they unload and they have trucks come in and they've got all this docking system. So he's a dock loader. He's been doing it for, I think, over 30 years. Trucks come in, they back up, they come in the dock, he loads, unloads. This situation was pretty avoidable, simple. So these trucks come in, there's a light outside that's green and red, and these truck drivers can see it. And this situation, the light was red. My client and his coworker were not done unloading the dock. He unfortunately stepped back in to complete the unload, and as he stepped back in, the truck driver drove off. It was undisputed, the light was red, and he drove off and slung my client off about 4 to 5 feet, where he landed on the ground, having a compound fracture in his leg, and he also broke his clavicle and had years of surgeries and rehab, and which led to this lawsuit.
Right. So was there a pre-trial offer?
Yeah, I mean, considering we litigated this for years, there were some offers. I think the highest offer was I think it was under $200,000. I think any formal offer was close to $100,000. The defense highly believed that there were OSHA violations on the employer. So my client's employer didn't do everything perfectly at this dock, but unfortunately, in Mississippi, the worker, the employer, is immune. They're immune from liability. And so they thought that most of the fault would lie on the employer for not having certain safety protocols in place, which may have led to this injury. So the defense didn't think as much of our claim as we did. And so the offers never got very high.
Right. I wonder if you could tell us a little bit more about the client. Like, what was his life like before the accident?
Well, I know Stephen pretty well. I say Stephen Barksdale, because he's been a client for now over 3 years. Great guy, hardworking, married to his high school sweetheart. And like I said, he'd been doing this type of work for his whole life. Right out of high school, he'd been around trucks, loading, unloading, hardworking. I mean, after the incident, he was pretty much disabled with his ability to work and walk, but he still worked. He still went to certain jobs and just trying to learn and earn a living for his family. Been very patient on this case since it happened in 2018. I think I could not think any higher of Mr. Barksdale.
Right. Once the case kicked off, what factors did it hinge on for you?
I mean, there was a video of the incident, so there was it was kind of clear what happened, but the factors were why it happened. Who messed up? I mean, it's obvious in the video that something went wrong, and I think there were several things that went wrong, such as the truck driver driving off with a red light. But there were also, like I said, OSHA violations there were no chalks. Chalks are small blocks that are supposed to be available for truck drivers to be put under their wheels to maybe prevent them from driving off. There's also mechanisms that actually lock the trucks into the dock. All these things were parts of this case as to who do we put the blame on? I mean, they tried to put blame on Mr. Barksdale as well for not for knowing these OSHA violations and not asking his employer to fix them. And we were fortunate that the jury put not 1% on Mr. Barksdale after the week-long jury trial. No one thought he had any fault, which we really liked. So it was basically we knew something was wrong and how much fault was supposed to be apportioned to the different parties.
So given that, what was the biggest obstacle that you faced in the case then?
I'd say the biggest obstacle we faced was defense counsel's OSHA expert. He was highly qualified expert that spoke for hours and talking about all the deficiencies that this immune employer had, which led to this incident. So I would say that he was by far our biggest obstacle because he was very good on the stand. He was very knowledgeable. He had been doing OSHA work for 40 years, I think. However, when we go to trial, we don't go to trial with one lawyer. It was me and Rocky Wilkins, who's a very skilled trial lawyer, as well as William Hackett, who's in my office, who's a brilliant lawyer. William's main job on this entire trial was to prepare for and go after this OSHA expert, which he did, and he did it very well. And I think that's something that our firm is privileged to have, is that we don't have to try cases with one lawyer. We are able to bring in a team of qualified lawyers to give our clients the best service. And I believe we did that here.
Let's take a step back. What considerations did you have during jury selection?
So jury selection, that is a massive part of a trial. That's a massive part of the focus that our firm puts on trials. And they're pretty similar usually in that we want to get a jury. We want to select 12 people that can listen to the evidence with no bias, that they don't come in there thinking that we're asking for too much money or that our clients are not that injured. Sometimes it's hard for people to hear about the damages that we're requesting and the client still be alive, that the client still has all their limbs. And we put a lot of time in trying to select that jury that is open to hearing about the pain and suffering, the loss of enjoyment of life, the medicals. And so Rocky Wilkins did our jury selection. He did the voir dire, and he does it as well as anybody in the country.
How then did you prepare for the arguments that opposing counsel might bring?
Considering the case had gone on for so long and that we had had several mediations trying to resolve the case, we felt comfortable with what their plan was, and to focus on that, those violations of the employer. And so we spent most of our time trying to have a theory of the case where that really wasn't the main focus for the jury, where, okay, there may have been some violations that the employer had that could have prevented this possibly, but that the main problem was this driver not paying attention. I believe, and defense counsel may not like me saying this, but I recall in the closing statement, the OSHA violations were brought up by defense counsel, and he said that those were there to protect human error, right? That you have all these safety precautions to protect against human error. But he forgot that his client was the human error. The defendant was the error. And Rocky Wilkins did our closing and, of course, made it known that if we hadn't had this error, the defendant, then we wouldn't have been here. And so, total team effort, and it was a great result for the client.
So you said there that Rocky did your closing. Can you give some information about how he prepared for those closing arguments?
So I've tried several cases with Rocky now, and the closing is something you prepare for day one. And so I did the opening, and then we took different witnesses. But someone that's doing a closing has got to relay to the jury what they've heard all week, right? And so Rocky is preparing for closing on every witness. So as he's listening to the witnesses that either I'm taking or William's taking or the defense is taking, he's preparing for his closing, every step of the way, so he can remind the jury of what the evidence is shown. And he does that, like I said, as well as anybody in the country.
Right. So you got this great verdict, and I'm not sure that you necessarily learn something from every case that you do, but Were there any takeaways for you from this case?
Yeah, I would say the takeaways is that never underestimate, the other side, which I don't think we ever do. We put forth our best case, and honestly, that the takeaway, it was reinforcing the fact that even in a considered conservative venue such as DeSoto County, Mississippi, if you put the case together and you do a good job and you have an unbiased jury, that in any venue they can return a fair and reasonable award, and so this trial is just another example of even conservative counties can see the evidence and give a big award.
Super. Ryan, thank you very much for joining us, and congratulations on the case.
Thank you. I really appreciate it, Carl, and glad to be here.
Super. Thank you.